If you became a United States citizen through naturalization, and you have recently seen headlines or social media posts warning that the government is expanding efforts to take away citizenship from naturalized Americans, I need you to pause right now and listen carefully. I understand the cold wave of fear that runs through your body when you read something like that. You worked so hard to earn your citizenship. You studied, you waited, you passed interviews, you took the oath, and you believed that chapter of uncertainty was finally closed. And now someone online is telling you it might not be permanent after all. I am here today to give you the complete truth about denaturalization, what it actually means, who it can realistically affect, and whether you need to be worried. Please subscribe to Immigration Path USA for the latest updates about immigration news and changes, so you can stay informed with accurate and reliable information. This channel is dedicated to helping you understand complex immigration topics without the panic, without the confusion, and without the misinformation that spreads so quickly across the internet. Let me begin by explaining what denaturalization actually is, because there is a tremendous amount of confusion about this term. Denaturalization is the legal process by which the United States government can revoke the citizenship of someone who obtained it through naturalization. This is not a new concept. Denaturalization has existed in American law for over a century. It is not something that was invented recently, and it is not something that can happen arbitrarily or without cause. The key thing you need to understand is that denaturalization is not deportation. These are two completely separate legal concepts. Deportation, or removal as it is officially called, applies to non-citizens who are in the United States and are ordered to leave. Denaturalization is a legal proceeding that first strips someone of their citizenship status, and only after that could removal proceedings potentially begin. The denaturalization process itself requires the government to file a lawsuit in federal court and prove its case before a judge. This is not an administrative action that can happen with the stroke of a pen. Now let me address the specific concerns that are circulating about 2026 and supposed expansions of denaturalization efforts. There are claims spreading on social media that the government is planning mass denaturalization campaigns targeting millions of naturalized citizens. There are posts suggesting that any naturalized citizen could be randomly selected for review and have their citizenship taken away. There are rumors that speaking certain languages, being from certain countries, or having certain political views could trigger denaturalization. I want to be very clear with you. These specific claims, as they are being presented on social media, are exaggerated and in many cases completely false. What is true is that the Department of Justice has had a denaturalization section for many years, and different administrations have placed different levels of priority on pursuing denaturalization cases. Some administrations have been more aggressive in seeking denaturalization for individuals who obtained citizenship through fraud, while others have focused resources elsewhere. These are policy priority decisions that can change from one administration to another. However, the underlying law about what constitutes grounds for denaturalization has not fundamentally changed. Let me explain the actual legal grounds under which denaturalization can occur, because understanding this will help you evaluate whether you personally have anything to worry about. Under current United States law, there are specific circumstances that can lead to denaturalization, and they are quite narrow. The first and most common ground for denaturalization is fraud, or willful misrepresentation in the naturalization process. This means that if someone lied on their naturalization application about something material, meaning something important that would have affected the decision to grant citizenship, the government can potentially seek to revoke that citizenship. Examples of material misrepresentation would include hiding a serious criminal history, lying about membership in prohibited organizations, concealing a previous deportation order, or assuming a false identity. If someone genuinely and honestly answered all questions on their application, and during their interview, this ground for denaturalization does not apply to them. The second ground for denaturalization is illegal procurement of naturalization. This means obtaining citizenship without actually meeting the legal requirements. For example, if someone was granted citizenship but they actually did not meet the continuous residence requirement, or they were not actually eligible for the green card that led to their citizenship, the naturalization could potentially be challenged. Again, if you legitimately qualified for your green card and legitimately met all the requirements for naturalization, this does not apply to you. The third ground involves membership in subversive or totalitarian organizations. If someone joins certain prohibited organizations within 5 years of naturalization, this can be grounds for revocation. This is a very specific provision that applies to a very small number of cases. The fourth ground involves dishonorable military discharge. If someone obtained expedited citizenship through military service and then received a dishonorable discharge under certain circumstances, this could affect their citizenship. The fifth ground involves refusal to testify before Congress about subversive activities within 10 years of naturalization. Again, this is an extremely narrow provision that applies to very few people. What I want you to notice about all of these grounds is that they require some form of wrongdoing, fraud, or failure to meet legal requirements. The government cannot denaturalize someone simply because they changed their mind about that person, or because of their national origin, or because of their political opinions, or because they want to reduce the number of naturalized citizens. Denaturalization requires a specific legal basis, and the government must prove that basis in federal court. Now, let me address what might actually be happening in terms of policy discussions for 2026 and beyond. It is true that there have been political discussions about immigration enforcement priorities, and some of these discussions have included talk about reviewing naturalization cases more carefully. There have been proposals at various times to increase funding for the Department of Justice section that handles denaturalization cases. There have been suggestions about using artificial intelligence or data matching to identify potential fraud cases more efficiently. However, there is a massive difference between political discussions and actual changes to the law. As of the time I am recording this video, the legal standards for denaturalization have not changed. The requirement that the government prove its case in federal court has not changed. The burden of proof that the government must meet has not changed. The due process protections available to naturalized citizens have not changed. If Congress were to pass legislation changing denaturalization procedures, that would be major news covered extensively by legitimate media outlets. It would go through committee hearings, floor votes in both the House and Senate, and would require the president's signature. You would know about it well in advance. Similarly, if the executive branch were to issue new regulations affecting denaturalization procedures, those regulations would need to go through the formal rulemaking process with public notice and comment periods. I want to directly address some of the most common fears I am seeing expressed by naturalized citizens. Many people are worried that old mistakes on their applications could come back to haunt them years or even decades later. Let me provide some perspective on this. First, the vast majority of application mistakes are innocent errors, not fraud. Writing the wrong date, forgetting to mention a brief trip abroad, or misremembering exactly when you started a job are not the kinds of things that typically lead to denaturalization. The government generally pursues denaturalization in cases involving deliberate deception about serious matters. Second, there are practical limitations on the government's ability to review millions of old naturalization cases. Even if an administration wanted to dramatically increase denaturalization efforts, they would need significant additional funding, staffing, and court resources to do so. The reality is that denaturalization cases are complex, expensive to litigate, and time-consuming. They require gathering evidence that may be decades old, proving intent, and convincing a federal judge. This is not something that can be done on a mass scale quickly. Third, courts have generally held that the government bears a heavy burden in denaturalization cases precisely because citizenship is such an important right. Judges do not take citizenship revocation lightly, and they require the government to prove its case clearly. Now, does this mean that no one should ever worry about denaturalization? No, that is not what I am saying. There are specific categories of people who may have legitimate concerns and should consult with an immigration attorney. If you obtained your green card through fraud, such as through a sham marriage, false asylum claim, or fraudulent employment sponsorship, and then naturalized based on that green card, you could potentially be at risk. If you deliberately concealed serious criminal conduct during your naturalization process, you could potentially be at risk. If you assumed someone else's identity or used false documents, you could potentially be at risk. If you fall into any of these categories, I strongly encourage you to speak with a qualified immigration attorney who can review your specific situation and provide personalized guidance. For the overwhelming majority of naturalized citizens who obtained their status honestly and legitimately, the current wave of social media panic is not justified. Your citizenship is protected by law, and it cannot be taken away without a court proceeding in which you have the right to defend yourself. Let me also talk about what you can do proactively to protect yourself and maintain peace of mind. First, keep copies of all your immigration documents, including your naturalization certificate, your green card, your passport, and any USCIS correspondence. Store these in a safe place and consider keeping digital backups as well. If you ever need to prove your status or respond to any inquiry, having organized records will be helpful. Second, if you are concerned about anything in your immigration history, consult with a licensed immigration attorney sooner rather than later. An attorney can review your file, identify any potential issues, and advise you on whether any remedial action is possible or necessary. Many people live with unnecessary anxiety for years when a simple consultation could provide reassurance or identify steps they can take. Third, stay informed through reliable sources. The official USCIS website, the Department of Justice website, and reputable legal organizations are good sources of accurate information. When you see alarming claims on social media, check whether you can verify them through official sources before accepting them as true. Fourth, be cautious about anyone who tries to exploit your fears. Unfortunately, there are unscrupulous individuals who prey on immigrant communities by spreading alarming misinformation and then offering their services to help you avoid problems that do not actually exist. Only work with licensed attorneys or accredited representatives for legal advice. I also want to take a moment to put denaturalization in broader context. The United States naturalizes approximately 800,000 to 900,000 new citizens every year. The number of denaturalization cases filed by the government is typically measured in the dozens or low hundreds per year, not thousands or millions. The vast majority of these cases involve individuals who obtained citizenship through clear fraud, not innocent mistakes or technical violations. The statistical reality is that denaturalization remains rare, and most naturalized citizens will never face any challenge to their status. This does not mean the issue is unimportant or that we should not pay attention to policy developments. It is always important for naturalized citizens to stay informed about their rights and about any changes to immigration law that could affect them. But staying informed is different from living in constant fear based on exaggerated social media claims. I want to remind you that this video provides general information about denaturalization law and policy. It is not legal advice, and it does not create an attorney-client relationship. Every person's situation is different, and if you have specific concerns about your own case, you should consult with a qualified immigration attorney who can review your individual circumstances. As we conclude today's video, I want to leave you with this thought. Citizenship is one of the most valuable and protected rights in the United States. The Founding Fathers and generations of Americans since then have recognized that citizenship should not be taken away lightly or arbitrarily. The legal protections that exist for naturalized citizens are real and meaningful. Yes, denaturalization exists as a legal remedy for cases of fraud and other serious violations, but it is not a tool for mass deportation or political targeting. If you obtained your citizenship honestly, if you answered your application questions truthfully to the best of your knowledge, and if you continue to fulfill your obligations as a citizen, you have every reason to feel secure in your status. Do not let social media panic undermine the peace of mind that you have earned through years of lawful presence, hard work, and dedication to becoming an American citizen. If this video helped you understand the reality of denaturalization and gave you some clarity amidst the confusion, please take a moment to subscribe to this channel and turn on the notification bell. I publish regular videos about immigration news, policy updates, and practical guidance to help you navigate the system with confidence. Your subscription helps this channel grow and allows me to continue providing free, accurate information to immigrant communities across the country. Please also give this video a thumbs up if you found it valuable. The like button helps the YouTube algorithm understand that this content is helpful, which means more people will find it when they are searching for answers. If you know other naturalized citizens who are worried about these same issues, please share this video with them. Send it to your family group chat, share it in your community Facebook groups, forward it to friends who might be anxious. Help me fight misinformation by spreading facts instead of fear. And please leave a comment below telling me your thoughts. Are you a naturalized citizen? What questions do you still have about denaturalization? What other immigration topics would you like me to cover? I read every comment and use your questions to guide future videos. This channel exists to serve you, and your input makes it better. Thank you for trusting Immigration Path USA with your time and attention. Remember, knowledge is power, and understanding your rights is the first step to protecting them. Stay informed, stay calm, and stay confident in the citizenship you have earned. I will see you in the next video.